So good afternoon and welcome to People Hour 18. I'm Paul Menham, a partner in the gunnercooke employment team, and today I'm going to be talking about a couple of really quite high profile cases that made the mainstream press, which is always quite exciting in employment law. Firstly, I'm going to be talking about what's been commonly referred to as the Uber case or the Uber decision. I'll then talk a little bit more about employment status, worker status and self-employment and how that arises, and that's fallen out of the Uber decision, and also the other big headline case that we've had over the past couple of months, the gay cake case as it's been called, although quite how a cake can be gay is possibly beyond me. So to begin with, the Uber decision. Now the Uber decision was a case that was brought in the London Central Employment Tribunal. The actual name of the case was Aslam and two others versus Uber BV and others. The reason that it was Uber BV and others was it was various different Uber group companies. One of Uber's arguments was to suggest that actually the London Central Employment Tribunal and the UK courts didn't have jurisdiction because they were a Dutch company. They were suggesting that if there was any contract at all, it was with a Dutch entity and therefore the UK courts didn't have jurisdiction. It would be covered by a different jurisdiction's law. It was one of their arguments that the London Central Employment Tribunal didn't particularly like. So most of you will be aware of what Uber is. For those who aren't, or just as a refresher, Uber is an app, or Uber operates an app that can be installed on most modern smartphones. And essentially, you utilise the app to call a private hire car. And it works for a consumer pretty much like it would calling a private hire car by phone and utilising a private hire car operator. In the usual app, it tells you how close a driver is, you book a route or you book a destination, it gives you an indicative price, and it tells you when the driver will arrive. You also pay for that online through the app. So from a consumer's point of view, it's quite good because one, the cars get there quite quickly, and two, you don't have to have change or you don't have to go to a cash point. So it's been quite a revelation. And in fairness, Uber's spread to the UK from America, and it has become something of a status symbol to certain cities. London was the first UK city to get Uber drivers. It has now spread across the country. We were very excited in Leeds when we got our own Ubers. But then again, we were excited in Leeds when we got electricity and hot and cold running water. So the Uber decision, what actually happened? Well, the Uber setup and the suggestion from Uber is that you can, as a private hire driver, you can run your own business and that you can be self-employed. And the Uber experience for a driver offers significantly more flexibility than a private hire company would do. As an Uber driver, you can pretty much choose your own hours. You can choose when you work. There are various things you can do. It's very good. It fits around other jobs for some Uber drivers. It fits around childcare for others. So it's quite a nice, flexible operation, and it's been very, very popular. There are, for instance, in London alone, over 30,000 Uber drivers, and there are thousands in other cities across the UK. So what was the issue? Well, as I mentioned, ultimately, the Uber setup is to suggest that the drivers are self-employed. And this case, the case of Aslam and two others, was a union-backed case by these three drivers suggesting that they weren't genuinely self-employed, that they were, in fact, workers. And the definition of worker is set out within the Employment Rights Act 1996. It's in section 233B. Now, worker is pretty much a European concept. The concept of employment and self-employment has been prevalent in UK law for a significant period, previously referred to, perhaps as employment previously referred to as master and servant, but generally the thinking was that we knew what an employee looked like and we knew what somebody self-employed looked like. I'll come on to that a little bit later this afternoon in terms of the blurring of the lines. But ultimately, this was not a challenge by three drivers that they were employed by Uber. They weren't suggesting that. They were suggesting, however, that they were workers, this sort of employee hybrid. And workers have some employment rights, but not all of the employment rights that employees would get. So, for instance, workers don't have the right to claim unfair dismissal. They don't have the right to minimum periods of statutory notice. They don't have the right to sick pay, to maternity leave, to all of those rights that attach only to employees, the right to transfer and a TUPE and the such like. The three main worker rights that would arise from this case would be an entitlement to the national minimum wage for periods when they were working, and a dispute actually arose as well as to when they're exactly working. An entitlement to annual leave, so to working time directive annual leave, and to protection if they whistle blew. So that if they did whistle blow, they'd be protected from being dismissed by reason of it or being subjected to a detriment. And the Uber decision, as I say, is only a first instance decision. It is only an employment tribunal decision, so it's not binding. However, it's the first real test of what's been described as the gig economy. And there are lots of models set up in this way, Deliveroo and others. And Uber is quite an important decision in that respect. Now, Uber put forward some excellent arguments, and I do have to say that Uber's documentation that sets out what they say occurs has been very well drawn up by some very clever lawyers, some very clever accountants, and is put together exceptionally well. And what Uber's arguments are, well, we're not a transport provider, we're not a minicab firm, we're a technology platform, and we're exclusively a technology platform. And what Uber sort of said was, well, we're a bit like eBay. So actually, if I decide to sell my bike and you decide to buy my bike from me, I'll put it up on eBay for £100, you'll offer to pay me £100, and I'll have to pay a small cut of that, perhaps a relatively large cut of that, to eBay. But nobody would suggest that eBay is the shop in that respect. Nobody would suggest that it's anything other than a transaction between me and you that eBay facilitates via a technology platform. And Uber was saying exactly the same thing. They said, well, actually, the contract is nothing to do with us. They said, well, actually, Uber in London is 30,000 small businesses. Each driver is a small businessman, and the drivers are in business on their own account. They make their own money. We don't dictate how much they earn. They dictate how much they earn. And the contracts that arise, again, there's not a contract between the passenger and the minicab firm as there would be in the traditional minicab arrangement. Oh, no, no. The contract is between, Uber say, the driver and the passenger. We merely act as an agent for the driver and facilitate that. So actually, that's what Uber say happens. They say, well, there's a small business, a driver, there's a potential customer who says they want to be driven from point A to point B. We, the technology platform, facilitate that and put them in contact. And they actually said, well, there's an invoice. Those of you who can see the slides will see that I've put invoice in air quotes, but there's an invoice between the driver and the passenger. And any contract that exists at all between Uber and the drivers is purely a commercial agency contract, i.e. we Uber act as the driver's agent to try to get them business for their small business. And that's Uber's argument. That's why they say, well, these people aren't our workers. We're certainly not their employer, but it's not about employment status, but we're not the business engaging these drivers. No, no, no. The drivers are in business on their own account. They're engaging with passengers, and we are merely a facilitator, a technology platform facilitating that trade or that transaction. Unfortunately for Uber, those arguments were given short shrift by the London Central Employment Tribunal, and it was a relatively lengthy hearing. And Uber called in their big guns. They called in their head of UK operations, who, unfortunately, the tribunal, in fairness, said that she absolutely stuck to her guns. She would not back down with regard to the contractual language that Uber were trying to use. And as I say, that language was set up in all the contracts and consistent on their internal documents to suggest that they were merely a facilitator and they were facilitating this arrangement for these small businessmen to passengers or customers for them, and they were merely setting them up. They weren't exercising any degree of control. And as I say, the witnesses for Uber came along and tried to stick to that story and did stick to that story. However, one of the quotes from the employment judge on this was, "The lady doth protest too much." They actually suggested that the contract between Uber and the drivers was full of what they described as twisted language that they said didn't reflect the reality of the situation. Also, unhelpfully to Uber, it contrasted with their language to the outside world, because to the outside world, Uber portrays that it is the business, that you contract through Uber. It refers to our drivers, etc. And that the court said it was going to view the contractual documentation with a degree of scepticism. The tribunal also said that the idea that this was 30,000 small businesses operating in London linked by a platform was faintly ridiculous. And as I say, the court didn't like the arguments is probably the understatement of the decade. In reality, the court found that the contracts that were in place were a fiction and didn't reflect the reality of the situation. They were a sham. Now, ultimately, the court said, well, the difficulty is, I mean, we're headed driver arguments, but these are the findings of the court. The driver doesn't know the identity of the passenger. The driver, once the passenger has made a booking and the driver's accepted it, was told the first name only of the passenger, and there was no check to ensure that it was actually the passenger's correct name. So ultimately, the driver is picking up someone called Bob. How can they effectively form a contract with somebody they don't even know who it is? And likewise, the passenger doesn't know who the driver is either. The price was set by Uber. Now, again, there was something, again, of a contractual fiction in play, or a purported contractual fiction here, because the price was set by Uber. Uber said this is the maximum price that can be charged for the journey because that's the price that was put back to the passenger and the passenger accepted. Now, they did say that drivers could, if they wished, reduce that price. Although why on earth the driver would agree to reduce that price is perhaps in question. But ultimately, they still have to pay the same amount to Uber. So again, it was something of a fiction to suggest that the price was in any way affected by the driver. It was set by Uber. The route was also set by Uber. Now again, the passenger and the driver could override that, but ultimately the route generally to be taken was set by Uber. It was calculated by their algorithms. So again, there was no control for the driver there. They couldn't pick and choose their route. There was also a rating, and there also is a rating system for drivers. So passengers are able to, and in fact encouraged, to give a star rating for drivers and highlight any concerns that they have about drivers, and that is dealt with drivers. So if drivers get consistently poor ratings, they can be dropped by Uber, which again, to the tribunals said, well, the reality is that's pretty much like a capability or a disciplinary procedure. If there are complaints, you deal with them, etc. They look like they're workers. Additionally, if there was a rebate to go to a passenger, Uber would decide that. It was nothing to do with the driver. It would cut the driver out of the loop on that. Uber bore the risks. So, for instance, there was a set amount that Uber would pay to a driver if a passenger soiled the car, generally was sick in the car. Uber would pay a set fee to the driver in order to get their car clean. So again, Uber was bearing the commercial risk. I'll come on to in a second why that's indicative of more like employment or worker status than self-employment. And Uber dealt with the complaints as well. It dealt with complaints which frequently ended up with rebates to passengers. But ultimately, if there was a complaint raised, it wasn't raised by the passenger to the driver, which Uber was saying was the contract. Oh, no. The complaint was dealt with by Uber, merely the technology facilitator, which again was inconsistent. And also, Uber can or could under the contract and did unilaterally alter drivers' terms. So they varied percentages, and there were other changes that they made, which again was more akin to a master-servant or an employment or worker contract than it was akin to a genuinely commercial contract. So the conclusion that the court reached, or the tribunal reached in this case, was that drivers were clearly workers, and therefore they were within section 233B. And in that case, they were entitled to the national minimum wage, they were entitled to paid annual leave, and they were entitled to whistleblower protection. The court took into account as well, when looking at the contract, the unequal bargaining position. Ultimately, Uber's contract, which was pretty much standard terms that they weren't prepared to depart from in any way, shape or form, drafted up by very clever and very expensive lawyers, accountants, tax advisors, versus the drivers who frequently had English as a second language and were faced with you either take it or you leave it. There was an unequal bargaining position. Again, more akin probably to a worker, business or employer-employee relationship. Now, a A couple of important things to point out about this case. Whilst I say it's quite exciting, whilst I say it's the new gig economy and this is a big decision, it is only a tribunal decision. It's only a first instance decision. Uber have already indicated that they will appeal. They have also gone out publicly to express their dismay and outrage at the decision, both via, as you would expect for a technology platform, both via standard media and via social media. Their example about eBay and various other e-commerce sites was one that I picked up from their Twitter account. It was also in respect of 3 drivers only, albeit that the findings are likely to be persuasive in respect of the other 30,000 in London and tens of thousands throughout the rest of the UK. And it's also important to point out that the tribunal was not considering whether the drivers were employees. Bear that in mind, this wasn't a test of employment status. It might well have been a different finding were it employment status. I don't know for definite. I would suggest it might well have been, though. It was about worker status, and the reality was they were very, very likely to be found to be workers, and I'll explain why in a minute. So that's the Uber decision, that's the Uber case. As I say, not landmark in the respect that it's a Supreme Court or Court of Appeal case that will affect everything that we do, but it is a very interesting first gig economy case and shows the likely direction of travel and the issues that can be raised about, theoretically, sham false self-employed or sham self-employment. And that's led me on to the second part of what I'm going to talk about this afternoon, which is about employee status, worker status and genuine self-employment and the differences between them. And the fact that actually this is becoming harder and harder to determine. Because the Uber decision demonstrates that the labels that the parties place on the relationship, whilst it is one factor that a tribunal or court will frequently take into account, it is frequently, or it is not necessarily determinative of that relationship. And sometimes, and the courts are not afraid to say that the label that's been put on is purely a sham. And employment or self-employment is a key issue to determine for a number of different reasons. It affects employment rights, obviously, of great interest to an employment lawyer or an HR advisor. But it also affects matters such as tax, the appropriate, how the employee should be taxed. Should they be paying national insurance contributions? It also affects insurance. It affects personal injury. An employer has an obligation that they cannot delegate to look after the health and safety of his employees. He must also provide them with protective equipment. Again, the employer can't delegate that statutory responsibility. So again, it's important to know who is an employer, in particular for insurance, to ensure that the right label is placed on persons working somewhere to ensure that they are covered for insurance in case of accident or injury. As I mentioned earlier, worker status is a newer concept. It's a European concept and it straddles this boundary between employment and self-employment. As I'll come on to in a second, all employees are definitely workers, but not all workers are employees. And some people who might otherwise be considered to be self-employed or not employees are also sometimes workers. Now, employment or self-employment, which used to be the A or the B, the black or the white test, it tends to be a multifactorial test. That is to say, a number of factors are taken into account in courts or tribunals deciding whether or not someone is employed or self-employed. And the answer to that question sometimes depends on who's asking, because there are certain courts, for instance, in dealing with personal injury claims, that the courts are probably more likely to consider someone an employee for health and safety purposes than other courts are for different purposes. The taxman equally sometimes will take a relaxed approach, providing tax is being paid, although there is currently a crackdown on sham self-employment and more regulations coming into force in that respect. IR35, the construction industry scheme, etc. And as I said, the labels used by the parties, part of decision making, but not conclusive. So what does employment look like? Well, I put down 8 or 9 factors here. I put down 9 factors. There's also a 10th factor, which is the label placed on it by the parties. And none of these is of itself determinative, with arguably one exception of personal service. Because without personal service, which is why it's at the top of that list, without personal service there cannot be an employment contract. There must be personal service for there to be employment. That is to say, if there is a genuine right of substitution, if I don't have to turn up today and I can send somebody of my choosing instead, then I cannot be employed, if that genuinely is a right. Now again, that means that it's commonly a clause that's inserted into contracts trying to assert self-employment, to try to say that an individual does have the right of substitution, can send somebody in their place. But again, it has to be a genuine right of substitution. And if it's been exercised, as I say, it cannot then be employment. But personal service of itself does not necessarily prove employment, because obviously there could be a contract that insists that a certain person attend and carry out the work as part of a commercial agreement. It would happen all the time. If you have a commercial agreement with solicitors, you might insert in it, well, we always want, for instance, Paul Menham to carry out our work. Equally, you might say we don't want him anywhere near our work and we want somebody else instead. But that of itself would not make me or that other person your employee. But if there isn't personal service and there is a genuine right of substitution, it cannot be an employment relationship. But personal service of itself is indicative of an employment relationship. Control is indicative of employment. Now again, I've put at least theoretically. At the end of the day, somebody self-employed generally controls the manner in which the work is carried out. They might be given a job, but ultimately someone who is self-employed can choose how they carry out that job. They're being paid for the job rather than the manner in which it's carried out. Now, again, once you get into highly skilled fields, the control becomes theoretical because, for instance, a surgeon or a consultant might be employed by a hospital trust, but it is a nonsense to suggest that the hospital trust would in any way try to control how that surgeon carried out an operation. It would be nonsense. You would have to leave them to their own devices because they are far more skilled than the person who would be purporting to do the controlling. However, there would still be a theoretical right of control that they exercise over their employee that, again, usually would not be present in self-employment. Not necessarily the case, which is why I say it becomes harder and harder to be able to assess where the distinction, where the gap lies between employment and self-employment. For there to be employment, there must be an obligation to provide and an obligation on the individual to accept work. And again, it is said that that is a fundamental of a contract of employment, although the advent of 0 hours contracts and casual employees muddies the waters here. In employment generally, it is more likely that there will be exclusivity. So if someone works only for one organisation, and if someone is allowed only to work for one organisation, again, it's fairly strongly indicative that that person is an employee, although it doesn't necessarily prove it. Payment of a salary. If the person is paid the same amount to turn up regardless of their output, again, it's fairly indicative of employment. Now again, in the modern world, obviously there are bonuses, there are commission structures, there are fee shares and things that might still apply to employees, but a salary, again in itself, a fixed amount for turning up and doing the job on a day-to-day basis is more akin to employment than self-employment. Fixed hours, or hours that are determined by the employer, is again indicative of employment status. Variable hours, or the employee or the person carrying out the work being able to determine their own hours, is more akin to self-employment. Where the risk lies, again, if the risk is with the employer, so if the job is carried out badly, if the individual gets paid to put it right, or still gets paid even if it's done badly, again, that's indicative of employment because you're paying the person to do the job rather than paying for the job itself. If you're paying for the job itself and the person gets the same amount regardless of if they do it within 2 hours, which is what you thought it took, or if they have to spend 16 hours to put it right, that's much more indicative of self-employment. In an employment situation, again, one would normally expect the equipment to be provided by the employer. If you're employed by someone, you'd expect them to provide the tools for the job. In the olden days, it was easier to tell because they provide you with the truck, the spade, the signage, etc. The personal protective equipment, which they would have to provide you with. Again, in the more modern economy, what are we looking at? Well, if the employer or if the business provides the laptop, the mobile phone, etc., those tools for the job, the email account, that is more indicative of employment status. And finally, integration within the business, and this falls back onto equipment a little bit, but integration within the business can often be a defining test, and it's often quite an amusing one when I talk to clients about employment, self-employment, because integration within the business can mean various things. Firstly, is it a core function of the business? A tribunal or a court is much more likely to accept that an ancillary function, so for instance, not doing your main function, not doing your main sales function, but doing the support, so doing the IT, doing the HR, doing the marketing, doing the legal work, doing the accounts. If it's not the central or core function, a tribunal is more inclined to find that you're not fully integrated with the business, and therefore it's more likely it could well be self-employment rather than employment. However, the other point about integration is how personally integrated that person is. So again, do they have a work email account from that business? Do they have their own desk at that business? Do they usually work out of that premises? Are they invited to the Christmas do? And this is where it starts getting silly. Do they come out? Are they treated like a normal employee? Are they invited to employee drinks? Are they appraised as employees are? Are they invited to internal meetings? Do they come? As I say, the Christmas do can become a vital arbiter in these cases, which might well seem odd. So again, the greater the integration of the business, the more they look like an employee because they're treated in exactly the same way as employees are. They have their own desk, they have a desk in the office, they have a computer supplied by the business, a phone supplied by the business, they have business cards supplied by the business, they have their own email address at the business. They look more like an employee. The converse is obviously also true. So self-employment, as I mentioned earlier, the ability to send a substitute is pretty much, or a genuine ability to send a substitute is pretty much a defeater of employment status. So a genuine substitution clause that is exercised would almost certainly point to self-employment. The rest of the factors, again, are only indicative and point to self-employment rather than proving it. So again, somebody self-employed in business on their own account tends to dictate the manner of work and is paid for the results. So they tend more often than not to be paid a set fee or an amount, and it's up to them how they then carry that out. You don't get in a plumber and say, right, well, firstly, I want you to unscrew that pipe, and then I want you to do this, and I want you to do it in that order. You pay a plumber to come in and fix your piping. And it's the same. They're clearly self-employed. Whereas theoretically, if you were engaging that person and they were an employee, you could dictate how they do the job. If they're self-employed, they've got no obligation to provide, or you've got no obligation to provide them with work, and they've got no obligation to accept it. Now again, blurring of distinctions here with the advent of casual workers or 0 hours contracts. But again, if the person can say, I'm sorry, I don't want that job, I just don't fancy doing it, it's more indicative of self-employment. How can they be your employee? There's no mutuality of obligation. They can work for others. They're not exclusively working for you. They can and do work for other people. It is a non-exclusive relationship, as I've heard it described in other scenarios. Again, usually, although not exclusively, there's a rate for the job. There's not a salary or an hourly rate. You pay a fixed price for the job. So you pay the plumber to come and fix your piping and you pay him 200 quid. Now again, that's not necessarily the case. I do appreciate you might still, not a gunnercooke obviously, but you might still pay your lawyer by the hour for a job. And the amount that they get depends on how much work they do or how long the job takes them. But it is more indicative of self-employment if there's a specific rate for the job rather than a rate per hour or a fixed salary. Hours may be agreed rather than dictated by the business or the employer. Again, not necessarily the case. It could well be that you contract out with a business to have somebody from 9 to 5 to deal with your outsourced IT, for instance, but it's more indicative of self-employment. The risks with the individual. So if something goes wrong, if the individual's work isn't up to scratch, it's up to them to put it right. It's not up to the business to pay them more to put it right. And again, the converse of what I was talking about earlier, the equipment generally for a self-employed person will be provided by that individual. So you would expect the plumber to turn up in his plumber's van with his plumber's toolkit with odds and sods of pipes. You wouldn't provide him with the tools when he gets there. Likewise, if somebody is self-employed, even if they're coming, usually you wouldn't expect to have them at your office, but even if you did, you'd expect them to be working on their own equipment, using their own laptop, using their own mobile phone, logging into your guest Wi-Fi perhaps, using their own systems and using their work email address. All of those types of things point to self-employment. And again, the integration with the business, those points that I mentioned above, unless you're inviting all contractors, you wouldn't expect to invite them to work drinks, your Christmas do. You wouldn't expect them to be carrying out the core functions of your business. If you're a law firm, you wouldn't expect them to be your lawyers. You might, however, they might be your IT staff or your HR staff or your PR people, for instance. So again, less integration with the business is indicative of self-employment. How does a court assess this multifactorial test? Well, I called it a multifactorial test, which is quite a mouthful. The other way I tend to refer to it is the duck test. Now, I do appreciate the duck test is not necessarily the only test here. Frequently, it's referred to as the dog test. Either is acceptable in employment law terms, and the duck test is pretty much, it looks like a duck and it quacks like a duck, and you therefore determine what it is. And the dog test is pretty similar, except it barks instead of quacks. But that's ultimately the way that the tribunal look at it. No one factor, save personal service, because that can be determinative, but otherwise no one factor affects it. They weigh it into the balance, which is why sometimes in certain situations, little things like IT systems, email addresses, where they work, how they work, whether they've got their own desk, all those little things can just tip the balance in finely tuned cases. So the duck test is pretty much what the tribunal do, and there's case law back and forth, and it is ever evolving, particularly these days with the gig economy and the different ways that people are now working. So worker status. Now this is the hybrid one. This is the one in the middle, and the reason for that is because this is section 230 of the 233B of the Employment Rights Act. So an individual who works under a contract of employment, so it was what I said, all employees are workers, or any other contract, whether oral or in writing, where the individual undertakes to perform personally, so again it's got to be personal service, any work or services for another party to the contract whose status is not client or customer of any professional business undertaking carried out by the individual. Crikey, that's nice and straightforward, isn't it? That's why the courts have wrestled with this one for a little while. What can you take out of that test? Well, I'd suggest you take 3 bits out of that. The first is personal service. To be a worker, you've got to give personal service. If you've got a genuine right of substitution, you can't be a worker. If you can send your brother-in-law in instead of you, you're not an employee and you're not a worker, essentially. Business undertaking. What does that look like? Well, this is similar to 3 of those tests that I mentioned for employment status. So, if there is control, at least theoretical control by the business, if there is exclusivity, and if the risk is borne by the business, then you are more likely to be a worker, essentially. So those 3 bits of that test that I mentioned before for employment. Plus, for workers, there must be a mutuality of obligation as well. You must have to do the work if it's offered to you. So where does that leave matters? Well, there are some examples of workers. These aren't all questions of fact for tribunals to determine or courts to determine, but by way of example of cases that tribunals and the EAT have set out, workers, and these are probably not employees of these organisations, labour-only subcontractors, so that's subbies on a building site. So often bricklayers turning up on a building site, is there any work today? Yep, they'll sign on as labour-only subcontractors. They're taxed as self-employed people under the construction industry scheme. However, they are almost certainly workers because they're providing personal service. Salesmen on commission-only contracts. Now, in this particular case, the court was persuaded this person wasn't an employee because there was no guarantee in respect of hours, etc., etc. However, he was paid by commission. He couldn't send a substitute. There was control about how he did his work. The court was satisfied that he was a worker. A doctor at a private clinic, similarly. So someone who worked for the NHS during the week, not that work, he was an employee there, but work that he did for a clinic, he had to do it, fairly obviously. He couldn't send his mother or somebody else in his stead or some bloke he'd met down the street. There was control about how he did the work. He was a worker. An LLP member, this was in a solicitor's firm where there was a fee share agreement in place. Because they were a member, they couldn't also be an employee. It was quite interesting. However, the LLP member, regardless, was still a worker. That was a whistleblowing case. So for those purposes, when she blew the whistle, she could claim a detriment. Profit share actors, so actors who aren't actually being paid a wage for the work that they do, but they're sharing in the proceeds of the box office. Again, personal service control, etc. Pimlico plumbers, which is perhaps the pre the technology age, the Uber drivers of their day. So Pimlico plumbers advertise generally. It's not that they're individuals who come out, but under the umbrella of an organisation that calls itself Pimlico plumbers. All of the individuals would call themselves self-employed and are taxed for self-employed purposes, but they have to give personal service, etc. The agreement that they've got makes them workers. So again, entitlement to national minimum wage, etc. And currently, until it's appealed, until we get a decision to the contrary, Uber drivers. A summary of this, the questions don't get any easier, and the difficulty that arises is 15, 20 years ago, it was probably an awful lot easier to say that person is employed, that person is self-employed, and we generally weren't worried about workers. It is a lot harder now because of a more fluid economy and more fluidity in roles. It's an awful lot easier when somebody sits at a desk for 20 years or works in a mine for 20 years to say, well, that person's definitely employed. It's a lot harder these days because the place of work is changing, the nature of work is changing. People are taking on portfolio roles and doing different jobs for different organisations and working as consultants. Millions more in the UK are claiming to be self-employed in the last 5 years alone, another 2 million are claiming to be self-employed. That might be the nature of the economy, that might be evil businesses doing it to people, or it might well be that the risk-reward appetite amongst the workforce is increased. Law firms 10 years ago had one model and one model alone of employment or self-employment if you were a partner and owned the firm. These days, again, there are different models that can be adopted, and the same goes for other professions and other jobs. What I would suggest is, in every case, sensibly consider the appropriate label, because the cost of getting it wrong can be very, very significant. Tax are put at the top. There can be severe consequences, and there are crackdowns in various industries on what the Inland Revenue deems to be false self-employment. And frequently, it's perceived by businesses to be a lot better to call someone self-employed, simply because they'll pay 11% less national insurance. It's better for the individual because they'll pay a lot less income tax. They'll pay a lot less national insurance, and they can take payments by dividends, etc. Very, very costly to get it wrong in tax. The revenue go back 6 years plus one. It can be very, very expensive. Usually their first port of call, funnily enough, is the business. Employment claims. Obviously getting the labels wrong, very important. If someone's an employee and you don't follow employment law, very, very costly potential tribunal claims there. And as I mentioned earlier, personal injury insurance. If someone is injured at work, if they're your employee, according to statute, according to the courts, you're liable for their injuries, and if you've not got insurance in place for them, again, could be very, very costly. So that's employment, self-employment, and Uber. I'll come on to the final case, and again, this arose out of a case that made a lot of the national press. And now, a couple of things I've got to flag at the outset. For those of you who can see it on the screen, these are Bert and Ernie. Now, Bert and Ernie, I have checked this, are not officially an out couple. Bert and Ernie are characters from Sesame Street and have been, at least since I was a child and probably before that. And Bert and Ernie have become something of a symbol for the gay community. I believe essentially based out of the fact that a lot of the scenes involving them, they're tucked up in bed, in their pyjamas, led side by side together. I believe they were the first male couple to be shown in bed on American television, and thus have become something of have become heroes for the gay community. Absolutely fine. I am not outing them, and I am not suggesting in any way that they are connected with this scenario. Their image was simply used. So from that starting point, this case is a Northern Irish case, and it's gone all the way up to the Northern Ireland Court of Appeal. So actually we do have now a binding judgment. And it's the case of Lee and Asher's Baking Company. Now, Asher's Baking Company is owned by a couple called Mr. and Mrs. MacArthur. Mr. and Mrs. MacArthur are devout Christians who believe that gay marriage is sinful. A customer, Mr. Lee, came into the shop and asked for the cake that you've seen on the previous slide to be prepared. He wanted that cake of Bert and Ernie and support gay marriage. written on the cake. And he wanted it for, I believe it was a gay pride march or something similar, or a celebration. And the shop assistant in Ash's Bakery, who was neither Mr. or Mrs. MacArthur, it was their employee, accepted that order for the cake. However, when Mr. and Mrs. MacArthur discovered that the order had been accepted, they cancelled the order. Mr. Lee, who was supported by, I think it was Stonewall, then took proceedings and brought civil proceedings, claiming that this was a breach of the Equality Act. It was a breach of equality legislation in terms of service provision. Now, the issue that arose in this case, and as I say, this has gone from first instance to High Court to now the Court of Appeal in Northern Ireland, but the same principles because the same law applies throughout the rest of the UK. We're looking in reality at a clash between equality laws here, because on the one hand, Mr. and Mrs. MacArthur's are saying, well, we have rights, we are Christian, we have religious beliefs, and we believe our Christian beliefs are being infringed by ultimately being forced or being made to prepare this cake with a message on that we are wholly against, that we do not support. Conversely, Mr. Lee is saying, well, hang on a second, I am gay, I am perfectly entitled to put a slogan or to ask for a slogan to be put on a cake that says support gay marriage. Support marriage is perfectly legal, and it is worthy, and it's protected under the sexual orientation discrimination legislation. They would not have treated, and this was accepted, they would not have treated someone who had asked for a cake that said support marriage in the same way, or support straight marriage. They would have happily produced that cake. So ultimately, this refusal was on the grounds of sexual orientation. And that ultimately was what the Northern Ireland Court of Appeal said was the relevant test. They said that the lower courts had actually applied the right test. What was the reason for the treatment? And the reason for the treatment was the message regarding sexuality or sexual orientation. What the court said is actually, we're not actually looking here at which takes precedence, because actually, Mr. and Mrs. MacArthur's, you've not actually had any rights infringed. Because ultimately, there's not going to be any reasonable belief or expectation that you, the bakers who happen to ice a cake, support gay marriage simply because you have provided a cake to someone that says that. So they said that we don't see that your rights have been infringed, but in any event, the right to equality would prevail. Now, what they did say, the Court of Appeal, was, well, it was possible to say, actually, we have a blanket policy that we will not put any political or religious messages whatsoever on cakes. Sorry, no political messages whatsoever. And that would have been perfectly legitimate because they would have been treating everybody the same. There would have been no less favourable treatment. But what they couldn't do was pick and choose. And they couldn't say, we'd have done it for anything else, but not for gay marriage. Now, in my view, I think that's been a relatively consistent approach, and I believe that that's consistent with the European Court of Justice decisions in Iwida and British Airways and others, which was 4 cases that actually went to the European Court of Justice, 4 UK cases, and specifically the cases of McFarlane and Liddell. And McFarlane and Liddell, I won't pretend to know which way round they were, they both related to conflicts between the employees' religious beliefs and their obligations to service users. One of the two was a registrar and didn't want to perform gay marriages. They didn't want to perform a ceremony for gay marriages. And the other was a sex counsellor who didn't want to give sex counselling to same-sex couples, both on the grounds of their religious beliefs. And this is frequently where these issues arise. And ultimately, the ECJ said in both of those cases that the religious beliefs did not trump equality laws. They were obliged to carry those out. They were obliged to not discriminate against service users. So if you like, equality law trumps the person's beliefs, if I can put it as succinctly as that. I think that's also been applied in the innkeeper case, it did make me smile, the Christian innkeeper who didn't want to take in strangers at Christmas time, that came to the Court of Appeal last Christmas. Again, a relatively similar message in terms of the fact that sexual orientation or other equality legislation overrode, if you like, religious beliefs if they came into conflict. So those are the cases that I'm dealing with today. So Uber, employment status, and the gay cake case. Let me just have a quick look and see whether there are any questions. Okay, I've got one question. So the question is, have you given any thought to self-employed lawyers labelled as consultant or solicitor in traditional law firms where they work exclusively on their own introductory work but use the firm's equipment, services, IT, letterhead, etc., and whether they have employment or unemployment rights in the event of termination, and if so, what those claims are likely to be? Okay, I mean, ultimately, again, it's going to come down to that multifactorial employment test and whether or not there has to be. I mean, I would have thought that there's likely to be personal service, and I would have thought that there's likely to be control. And bearing in mind that the LLP member was found to be a worker, I would have said self-employed lawyers in that sense are very likely to be held to be workers. I couldn't put it any higher than that without knowing more, but I would say I would be very surprised if they weren't workers. Whether or not they're employees is a different question because the employment threshold is that much higher. And again, that's likely to be determined by a multitude of factors, including the equipment service, which is all part of the integration test. The risk and reward might bear very heavily on that. Likewise, the mutuality of obligation. Do they have to attend every day or can they choose? Do they have to take on the work? That's likely to have a significant bearing. If they did, then it might look more like employment status, but these are very, very much questions of fact. It's a little bit of a cop-out, but they're very much questions of fact that turn on, sometimes, as I say, the smallest factors. But I would be very surprised if those lawyers aren't workers. Even if they're not employees. Okay, let me just see if there's any other questions that have come through. No, it appears not. So, if there's nothing further, I will just simply conclude by saying that next month's People Hour is a People Hour special, and it's not simply special just because Simon Horsfield's hosting it. It is actually a special People Hour in December, and for that festive treat, Simon's going to be talking about modern slavery. So it is quite an interesting one. Modern slavery is becoming more and more of an issue to businesses across the UK. Obligations for modern slavery are, it seems, or in my experience, are being ignored, and it is a major issue, and employers are going to have to take more and more steps. So a very interesting and thought-provoking seminar coming up in December. Details will be sent out via our email list as usual. But if there's nothing further, I will say good afternoon for now, and thank you for listening.